Hello, welcome to Delhi Law Firm. Today, we are going to discuss a very important judgment delivered by the Supreme Court of India in 2026. This case is related to the PCPNDT Act, that is the Preconception and Prenatal Diagnostic Techniques Prohibition of Sex Selection Act, which is a strict social welfare legislation enacted to prevent female feticide in India. In this detailed awareness discussion, we will understand the background of the case, the allegations, the legal arguments, what the High Court held, and finally, what the Supreme Court decided in its final judgment.
Before we go into the facts, it is important to understand the objective of the PCPNDT Act. This act was enacted to prohibit sex selection before and after conception and to prevent misuse of diagnostic techniques for determining the sex of the fetus. The act aims to protect the dignity and life of the girl child under Article 21 of the Constitution of India. The Supreme Court has repeatedly described this law as a powerful social reform legislation meant to address the declining sex ratio in the country.
Now, let us come to the facts of the case. On 17 September 2015, a complaint was allegedly received in Gurugram that illegal sex determination was being conducted. Based on this information, a raid was planned by the district appropriate authority. A pregnant woman was made a decoy patient. It was alleged that Rs 25,000 was demanded for conducting sex determination.
According to the prosecution story, Dr. Abdul Qadir accepted the money and stated that the ultrasound would be conducted by Dr. Naresh Kumar Garg. It was alleged that Form F was not properly filled, no signature was taken and no entry was made in the register. During the raid, 25,000 rupees was recovered from Dr. Abdul Qadir. Importantly, no money was recovered from Dr. Naresh Garg.
An FIR was registered. However, after police investigation on 28 October 2015, the trial court discharged Dr. Naresh Garg. The police found no material to show that he had disclosed the sex of the fetus.
Yes, that is a crucial point. The police clearly stated that there was no evidence of sex determination by Dr. Garg. However, they noted certain discrepancies in record maintenance.
Despite the discharge in the FIR case, later in 2018, the District Appropriate Authority filed a complaint under the PCPNDT Act. In 2022, the Judicial Magistrate issued summons against Dr. Garg.
Dr. Garg approached the High Court under Section 482 of the Criminal Procedure Code seeking quashing of the complaint and summoning order. The High Court dismissed his petition.
Thereafter, the matter reached the Supreme Court. The key legal question before the Supreme Court was whether the raid conducted on 17 September 2015 was legally valid.
Under Section 30 of the PCPNDT Act, the power of search and seizure must be exercised by the appropriate authority. In this district, the appropriate authority consisted of 3 members: the civil surgeon, the district program officer, and the district attorney.
However, in this case, the order to conduct the raid was issued only by the civil surgeon, who was the chairperson. There was no record to show that the other 2 members participated in the decision.
The Supreme Court relied heavily on its earlier judgment in Ravindra Kumar v. State of Haryana. In that decision, the court clearly held that a search under Section 30 must be a collective decision of the appropriate authority. If a single member authorizes a search, the search becomes illegal.
Applying that principle, the Supreme Court observed that there was nothing on record to show collective application of mind by all 3 members. Therefore, the raid was not legally authorized in the manner required by law.
However, the court did not stop there. It also examined the larger issue, whether the prosecution could continue when the foundation of the case was an illegal search.
The court noted that the FIR had already resulted in discharge. The subsequent complaint was based substantially on the same facts arising from the raid.
The court clarified that while the PCPNDT Act gives independent authority to file a complaint, the prosecution cannot be sustained if the foundational search itself is illegal and the material collected flows from that illegality.
At the same time, the Supreme Court emphasized the seriousness of the PCPNDT Act. It referred to its earlier judgment in Federation of Obstetrics and Gynecological Societies of India (FOGSI), where it was held that complete and accurate maintenance of Form F is mandatory.
The court reiterated that non-maintenance of records is not a minor clerical lapse. It is considered serious because records are the only safeguard to ensure that sex determination is not taking place.
But in this specific case, there was no evidence that Dr. Garg disclosed the sex of the fetus. The primary allegation of sex determination was not supported by evidence.
Therefore, after analyzing the legal position and the facts, the Supreme Court concluded that continuing the prosecution would amount to abuse of process of law.
Accordingly, the Supreme Court allowed the appeal, set aside the High Court judgment, and quashed the complaint and summoning order against Dr. Naresh Garg.
This final judgment sends two strong messages. First, the PCPNDT Act must be implemented strictly to protect the girl child. Second, enforcement authorities must strictly follow the legal procedure laid down in the statute.
The court made it clear that strong laws cannot be enforced through procedurally defective actions. Rule of law requires both substantive compliance and procedural compliance.
For doctors, this judgment is a reminder that Form F, monthly reports, declarations and proper documentation are absolutely mandatory.
For citizens, it reinforces that illegal sex determination is a serious offense and should be reported.
And for those facing prosecution, it highlights the importance of examining whether the search, authorization and complaint comply with statutory requirements.
This judgment demonstrates the balance between social justice and individual legal protection.
Law must protect society, but it also must protect individuals from unlawful prosecution.
If you are facing any issue under the PCPNDT Act or any criminal proceeding, proper legal strategy is crucial.
For legal assistance and detailed consultation, visit www.dellylawfirm.news.